Chair.
Senators, I am going to suspend the committee to assume the chair and deal with the procedural motions.
We're going back into regular.
Acting Leader of Government Business.
Madam President, in accordance with Standing Order 14.5, I beg to move that the Senate continues to sit until the completion of the business at hand.
Honourable Senators, the question is that the Senate continue to sit until the completion of the business at hand. Those in favour say aye. Aye. Those against say no.
No.
The ayes have it. This Senate will continue to sit until the completion of the business at hand.
Check, can I get a division on that? No, you check. Yes. I do not know what the business at hand is.
Madam President, we propose to complete the bill before us and the committee stage, and we also propose to pilot the property tax amendment bill tonight.
All right. May I just say that a division has been called. The division was called without reference to any discussions, and therefore the division has to take place. Okay?
Mrs. Gopi-Schoon.
The motion is that the Senate continues to sit until the completion of the business at hand. Yes.
Madam President, if I may make a suggestion, considering the request for clarity from the Senator, and I'm sure we all will have that desire for clarity, perhaps we could ask the mover of the motion to clarify his motion and do it over.
Members, if I may say this, may I say this, please? This is rather unorthodox. Rather unorthodox. There is supposed to be collaboration among members, and therefore a division has been sought, and therefore I have to now go through with the division. Okay?
Mrs. Gopi-Schoon.
Yes.
Senator Batiste Primus.
Yes.
Senator Rambarat.
Yes.
Senator Sinanan.
Yes.
Senator Hussain.
Yes.
Senator West.
Yes.
Senator LaHunt.
Yes.
Senator Henry.
Yes.
Senator Singh.
Yes.
Senator Cummings.
Yes.
Senator De Freitas.
Yes.
Senator Duki.
Yes.
Senator Huggins.
Yes.
Senator Lewis.
Yes.
Senator Romano.
Yes.
Senator Mark.
No.
Senator Haynes.
No.
Senator Amin.
No.
Senator Hussain.
No.
Senator Obika.
No.
Senator Ramdeen.
No.
Senator Mahabir.
No.
Senator Roach.
Yes.
Senator Small.
Yes.
Senator Shriki-Soon.
Yes.
Senator Ramki-Soon.
I abstain.
Senator Choate.
No.
Senator Crease,
No.
Senator Raful,
No.
Senator Richards.
Yes.
Madam President, the results of the divisions as follows. 19 members voted for, 10 members voted against, and there was 1 abstention.
Honourable Senators, the result of the division is as follows. 19 members voted for the motion, 10 members voted against, and 1 member abstained. So therefore, Honourable Senators, this Senate will continue to sit until the completion of the business at hand. I just want to point out one thing. I did not feel it was proper to say it before the vote was taken because the division was called and therefore the vote had to be put into motion. But it is my recollection that when we adjourn on the previous sitting, the leader of government business will indicate what the business will be, of the Senate will be for the next sitting. That's my recollection. Honourable Senators, we shall now resume committee.
Clause 3. You want to? Sure, sorry.
Honourable Senators, we are reverting to Clause 3, which had been stood down. I don't think that there were any amendments circulated for Clause 3, but some suggestions were made as we sat in committee. So, Minister.
Thank you, Madam Chair. Madam Chair, I have conferred with the AG and his team, and we are of the view that the provision as currently drafted is adequate, and so we are not proposing to accept any amendments to this clause.
Clause 3 revisited.
Honourable Senators, the question is that Clause 3 stand part of the bill. Members, Honourable Senators, the Minister has indicated her position. Are there any questions or comments? Clause 3.
Minister, you just want to again in terms of
The matter that was stood down related to whether we needed to state specifically that there should be appeals to the Court of Appeal and the Privy Council.
Okay.
And the Attorney General and his team advised me that that is not necessary.
okay.
Senator Ramdeen.
Madam Chair, for the purposes of the Hansard, I wish to indicate and place on the record the fact that I am of the view that without the statutory provision inserted, that a person who wishes to exercise a right of appeal from the High Court to the Court of Appeal and to the Judicial Committee of the Privy Council will not have that right of appeal. If the government chooses to pursue that course, let them so do.
Any other questions or comments? Minister?
Madam Chair, we did discuss that issue with the Attorney General. As I said, we are satisfied with the clause as is.
All right. So honourable senators, the question is that clause 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no.
No division.
Senator Gopi School,
Yes.
Senator Batiste Primus,
Yes.
Senator Rambarat,
Yes.
Senator Sinanon,
Yes.
Senator Hussain,
Yes.
Senator West,
Yes.
Senator LaHunt, Senator Henry,
Yes.
Senator Singh,
Yes.
Senator Cummings,
Yes.
Senator De Freitas, Senator Duque,
Yes.
Senator Huggins,
Yes.
Senator Mark. Oh, I'm sorry. Senator Lewis.
Yes.
And Senator Romano.
Yes.
Senator De Freitas.
Yes.
Senator LaHunt.
Yes.
Senator Mark.
No.
Senator Haynes.
No.
Senator Amin.
No.
Senator Hussain.
No.
Senator Obika.
No.
Senator Mahabir.
Oh, so what about?
Senator Roach.
Abstain.
I'm sorry. Senator Ramdeen.
No.
Sheets. Out of sheets. Senator Small.
Abstain.
Senator Shriki
Abstain.
Senator Ramkisoon.
No.
Senator Ramkisoon.
No.
Senator Choate.
No.
Senator Kreese.
No.
Senator Raful.
No.
Senator Richards.
No.
I definitely need to know what it is. So the results of the division is as follows. 15 members voted for. 11 members voted against. And there were 4 abstentions.
Honourable Senators, the result of the division is as follows. 15 members voted for, 11 voted against, and there were 4 abstentions. So, therefore, now stands part of the bill.
Clause 15 revisited.
So, Honourable Senators, as we revisit Clause 3, the question is that Clause 15, as we revisit it, I remind you that we have amendments on behalf of the Minister, on behalf of Senator Mark, on behalf of Dr. Mahabir, Senator Shriki-Soon, Senator Ramki-Soon, and Senator, I said Senator Mahabir already, right? Yeah. Yeah. We were, when we deferred Clause 15, Minister, we were dealing with the amendment circulated on your behalf. Okay, so Senator Mahabir, we will now deal with your proposed amendment.
Thank you very much, Madam Chair. Madam Chair, I am referring to 25A2, but it has to be read in conjunction with 25G5. 25G5 contemplates that an act or proceeding of the Valuation Tribunal shall not be regarded as invalid because of a defect in the appointment of a member of the Valuation Tribunal or a vacancy in its membership. My reading of 25G5 is that the tribunal can conduct its proceedings, as indicated in the first few words, even if there is a vacancy in its membership, so that it is possible for the tribunal to sit not as a tribunal of 3, but with a membership of 2. I want to look at the construction of 25A2, the Valuation Tribunal. It says the Valuation Tribunal shall be a chairperson who shall be an attorney at law with 10 years of experience or more, 2 other persons, one of whom shall have wide knowledge and experience in the valuation, and 1 other person whose job description or whose qualifications is not defined. The concern I have, and hence the reason for the amendment, is that if this tribunal, for any reason, sits with 2 persons, the chairman, who is the attorney at law, and 1 other member who is a member at large, it is quite possible that the tribunal will sit to hear matters of a particularly specialized nature with 2 individuals without any one of them having any specialized training in the field, which in my mind contravenes the objective of one of these specialist administrative tribunals. And if such is the case, I see opportunities arising for the decisions of the tribunal to be contested, which is what we do not wish to have. What I am proposing is that the tribunal shall consist of a chairperson who shall have wide knowledge and experience in the valuation of property, so that the chairperson who is overseeing the proceedings of a tribunal shall be the one with wide knowledge and experience in the valuation of property. The attorney at law with 10 years or more of experience as a second member, and 1 other suitably qualified person drawn from the construction or real estate sector. Let me justify 2A. Once the chairperson of the tribunal is someone with the experience in the valuation of property, I think we will always have the confidence as members of the public that the proceedings of the tribunal will be chaired by the person with the expertise. The attorney at law, you see, is someone whose specialty is undefined. One hopes that he has experience in the field, but as the law is constructed, he could be 10 years experience in air and space law or in commercial law, and not necessarily in the area under review. And third, Madam Chair, it says 1 other qualified person. I would like the government to consider this other person not to be someone without specifications on qualifications, but this person drawn from the construction or real estate sector. Construction, he may be a quantity surveyor, so he has experience in the valuation or at least the costing of buildings. Real estate, he has experience both in real estate and in land and buildings. And I think in this situation, since the law is contemplating 2 persons sitting, we can have really the chairperson and the attorney at law, the chairperson and 1 other suitably qualified person from the real estate sector, in the understanding that this tribunal, given my own experience in tribunals, always has legal expertise within the organization, so that if the lawyer is absent, there is the legal advisor to the tribunal who is always there to provide whatever legal advice is needed. So I am placing in the interest of having the tribunal function efficiently as tribunals should, forward without there being any question as to their ability or any question as to the technical competence of the tribunal to make determinations, I am placing this particular amendment for the consideration of the Honourable Minister.
There's another component to your amendment.
Yeah. The other component, Madam Chair, to delete paragraph B, which was just hanging there, the Minister has recognized that, and in the Minister's submission for amendment, she has in her clause 15F, she says, in proposed section 25H, delete paragraph B and renumber paragraph C to D, so that this is the same amendment that I had requested.
Minister?
Yes, Madam Chair. Madam Chair, I would point out that the subsection 5 of section 25G that the Senator refers to does not require the chairman to be one of the two people sitting. So I don't know that the amendment that you're proposing addresses that issue. In addition to that, we have the view that because this tribunal will be exercising judicial power, that it should be chaired by an attorney at law to deal with the rules of natural justice and proper procedure and so on. If the person who is missing from the tribunal is the person with the specialist expertise that is required, there are two issues. One, the issue before the tribunal may or may not require that specialist expertise, and two, if it does, the chair then has the option to either adjourn that particular matter or to seek assistance from somebody else with expertise. So we do not think it is necessary to put the person with valuation expertise as the chair.
Just one counterpoint, Madam Chair, through you. Is it that 25G5 says that the chairperson of the tribunal can then be any one of the three? Because, you see, an act or proceeding shall not be regarded as because of a defect in the appointment of a member. So I am saying that if there is a defect in appointment, or if there's a vacancy, and the vacancy happens to be the person with the technical expertise, I can see good grounds with only the attorney and the other person at large alone administering the proceedings of this tribunal, making decisions which are going to be subject to appeal, and it is something you do not wish to have. But if, of course, you, as the Honourable Minister, is of the view that with the composition, the concerns I have is not a major concern, then, of course, I will withdraw the amendment.
Just to add that we do have a similar situation in the Tax Appeal Board where the court is constituted mainly by people who have legal expertise and accounting expertise because of the nature, and that matter has been addressed and has not caused any significant concern, so we do not anticipate that this will.
Okay, fine.
Madam Chair, before Senator Dan withdraws his amendment, I just have
Senator Mahabir.
Senator Mahabir.
Yes.
Habit is bad. Thank you, Madam Chair. I just have a question in relation to this amendment. Is there a clause, Madam Minister, to allow the chairperson or chairman to appoint someone with specialized skills to assist the tribunal? Is there a clause that says that?
No, there is not.
Now
but as I indicated previously, the tribunal is being given the power to create its own rules. Yes. And within that, they can give themselves the ability to call on expertise as and when they require that expertise.
Right, and that was my other question. These policies and procedures are being developed, and these points will be taken into consideration, hopefully. Right, thank you.
Senator Ramdeen.
Madam Chair, I was wondering if the Minister could clarify with respect to subsection 5, where we are providing, there are two things I have an issue with. The first one is that any act or proceeding, if you're trying to preserve the acts and proceedings of the tribunal as being valid because of a defect in the appointment of a member. And I was just wondering, what is the mischief that we are trying to cure by providing that there would be a defect in the appointment of a member?
Minister, I'll ask you to respond, but I will point out that right now we are dealing with the amendments as proposed by Senator Mahabir.
I thought that was, as you please, ma'am.
No, I've asked the minister to respond, but I'm just pointing out for...
I thought, I may have been mistaken, Madam Chair, and I apologize. I thought the amendment by Senator Mahabir had to do with the subsection 5 of 25G.
Senator Mahabir made reference to the section, and that is one of the reasons he said, because of that section, that he thought that this amendment would be prudent.
Yeah. Perhaps I can leave that and just deal with the other part that Senator Mahabir has raised about the vacancy in the appointment. Without us providing for there to be a quorum for the tribunal to function, what is going to happen is that the provision that you are enacting, in my respectful view, at 25G subsection 5, with respect to what Senator Mahabir has raised about, or a vacancy in its membership, is going to not only result in there being a position where the tribunal can operate with 2 members, but on this interpretation, the tribunal could operate with 1 member.
Minister?
No, Madam Chair, we do not agree that the tribunal can operate with 1 member. As I said, there is a lot of precedent for this approach, and the tribunals either operate with 3 members or with 2 members. So I do not agree. I would refer the senators to 25I subsection 4, which says that the Valuation Tribunal may receive and take account of any relevant evidence or information, whether or not that evidence would be admissible in court proceedings. This gives the Valuation Tribunal significant power to call for such information and such assistance as it would require. So we think that adequately addresses and subsection 3. We think that adequately addresses the tribunal's power to supplement any absence of expertise in any particular area.
Senator Mahabir?
No, I raised it. If the Honourable Minister is of the view that the mischief I'm trying to avoid is not as large as I'm seeing it, then I will be withdrawing the amendment.
So, okay. So the amendment proposed by Senator Mahabir is withdrawn. Senator Ramkisoon, can we deal with your proposed amendment?
Thank you, Madam Chair. I do have an amendment to my clause submitted, which is... So it states, notwithstanding that a member term of office has expired, with the permission of the President acting on the advice of the chairperson, continue in office for such a period after the expiry of his term as may be necessary to do anything in relation to the completion of proceedings that were commenced before the tribunal before his term of office expired. And Madam President, this thought came about after listening to Senator Cree's contribution, where he asked for the time period to be amended. And I thought of another way to go, because I looked at our existing law in relation to how we look at tribunals, and we have the Equal Opportunity Tribunal of Trinidad and Tobago, and they actually have in their legislation a provision to ensure that members who have been appointed, if a matter is before them, they can continue once the chairperson sees it fit, can allow the president to appoint that person to allow them to continue to sit until that matter has closed. So it doesn't affect appointments of the 3-year appointment that we have in the bill. I'm not sure if the minister caught all of that. Okay.
No, there's another component to your amendment as well.
Subsection.
There's a B. Yes?
So you want to deal with subsection 25E as well?
I want to deal with the amendments that you have circulated in respect of clause 15.
All right, so in the proposed subsection 25E, I also have the concern about members who may be absent and vacant posts, and how the tribunal will be dealing with this, and that's why I chose to insert or propose a clause be inserted to cover such, so where a member is ill or otherwise unable to act, or where his office is vacant, the president may appoint a temporary member to act as the case may be, and just really to ensure that you have your 3 members present for your tribunal.
Minister?
Madam Chair, I'm advised that the Interpretation Act adequately addresses the issue of a member being able to continue in office to conclude his any work that is before him, so that we are not of the view that this amendment is necessary. Similarly, with respect to an individual being temporarily incapacitated, the reason why we can sit with 2 rather than 3 is to allow for situations like that, and we have not come across any of the tribunals where we have had difficulty in relation to this matter, so we are not minded to accede to either of those recommendations, Madam Chair.
Madam Chair, thank you.
No, just before, Senator Roach
Yeah,
wants
Madam
to say
Chair, can I
something.
just raise a question with the Honorable Minister, please? 25E, where you have 2 persons, right? A decision is made, any decision is made by a majority of the tribunal, which is when you sit with 3, so a majority, 3 will be 2. When you have 2 persons sitting, what is the majority when they are not agreeing? How are you dealing with that?
Where I have seen 2 members sitting, the 2 members will have to agree on the decision, or it will not be a majority.
Exactly, so you don't have a decision.
Yes, that is correct. Yeah, so they'll consider the matter. As I said,
So the
Senator.
business will be concluded. So the business will be concluded if you don't have it.
They can do one of 2 things. They can review the issue and determine whether it is the matter is of such significance that they need a 3rd member, and if that is so, they can defer the contemplation of the issue. And if they think that the matter is simple enough that 2 of them can determine it, then they can proceed. As I said, we have this situation going on daily with tribunals like the Tax Appeal Board, and it has not stymied the operation of the tribunal.
Senator Ramkissoon wanted to say something before.
Oh, yes. Thank you, Madam Chair. In relation to the response by the Minister, now, I made a reference to a tribunal existing in Trinidad and Tobago. The Tax Appeal Board, I wouldn't look at it as a tribunal per se. You're looking at the equal opportunity. Now, this law was assented to on the 20th of October 2000. And there is a provision when you look at the tribunals where this clause assisted. And I'm not sure why the government is reluctant to include such a clause, because it's not, if you're saying it's not against the Interpretation Act, then why not put this in at this time?
Senator Hussain.
Thank you, Chair. With regard to the function of this tribunal, it's a judicial body, and earlier on the Minister indicated that 2 members can sit and then they decided whether a 3rd member sit. Now, this tribunal has the power in order to take evidence. So I could imagine that if 2 members sit and hear the evidence, then a 3rd person cannot come and then make a decision on the evidence that was heard by 2 members sitting previously. So there will be a deficiency in the entire process, because the matter now becomes part heard before 2 individuals, and you cannot then include a 3rd individual to consider the matter. That's an illegality on itself. So I think we need to cure this mischief.
Questions or comments? Minister?
Madam Chair, if you can give us a few minutes, we are reconsidering the recommendations.
Sure.
She's looking for
Minister, do you need some time? Yes, we do. Okay, so what we
Madam
will
Chair.
do is
Move on to the others.
move on to the amendment proposed by Senator Shriki Sood.
I'm happy with that, Madam Chair. Thank you.
Senator Shriki Sood.
Thank you, Madam Chair. To the Honourable Minister, in perusing the Act and going through the Act, I've realized that you've made arrangements or there is provision for improvements, so that when improvements are made, there is a procedure whereby new valuations can be conducted when that's done. However, given that the
Senator Shriki Sood, you have an amendment, a proposed amendment to clause 15, and then you have a new clause 15. We're actually dealing now with the proposed amendment to clause 15.
to clause 15. Oh, sorry.
Yes, because we deal with new clauses
Sure,
when
sure.
we finished all the other clauses.
Thank you, Madam Chair. My apologies. To the Honourable Minister, the intent of my amendment here was for the independence of the tribunal, and when I used the word president, I used it in the context of the President of the Republic of Trinidad and Tobago, and hence I thought that office would lend a lot of independence to the establishment of the tribunal. So, thank you, Madam Chair, for allowing me.
Renumbering the removal of, apart from deleting minister and substituting with president.
Thank you, Madam
BNC.
Chair. Thank you, Madam Chair, again. So for the, if it is that the amendment is accepted, then with respect to the 25G, yes, 25G, where the minister shall not, and it says here, the minister shall not give directions to the Valuation Tribunal. If it is that, yes, thank you. Subsection 2, if it is that the President of the Republic is accepted as the position or the person to appoint, then that clause would not be relevant, and hence I asked it to be.
Okay. Minister?
Madam Chair, we have revisited the issue of the appointment of the tribunal, and we are prepared to follow the position adopted in the Tax Appeal Board Act, which gives the president to appoint the chairperson of the tribunal on the advice of the Judicial and Legal Service Commission, and the other members of the tribunal are appointed by the president without more. So this is what we are proposing to the members to bring us closer to a common position on this issue.
Senator Shriki Sood.
Thank you, Madam Chair. Madam Chair, I appreciate the accommodation of the minister to entertain the change or the proposed amendment. However, if it is that the tribunal comprises 3 people and you have 1 person being elected by the president in consultation or with the assistance of the Judicial and Legal Services Commission, then what you would have is the majority of members on the tribunal being appointed by the minister. And the whole goal of this is to bring independence to the tribunal.
Minister?
Madam Chair, we have operated the Tax Appeal Board with this equation, on this basis, for years without any indication that there has been any interference from anybody in terms of their operation. They operate like an independent tribunal. I have heard no accusations otherwise, and so I think that the accommodation in the circumstances is a reasonable one.
Madam Chairman, if I may.
One second, Senator Choate.
Yes, may I just speak in support of Senator Shriki Sood's proposal? I don't see that changing the chairman to be someone appointed by the JLSC with the 2 other members still, being under the difficulty that we had perceived when we had last come to discuss this matter is going to change anything at all. And the fact that the composition of the Tax Appeal Board may have worked well in the past really is sort of irrelevant in my mind, because we are looking at a new piece of legislation and we are looking at its operations moving forward. So I would imagine tribunals in the past have worked well and have not worked well. So to single one out and to say that that should be an example for this particular one, I think is a dangerous logical connection. And I think that there is nothing difficult, I don't see what is difficult or controversial about protecting the independence of the tribunal in the best possible way. So I support Senator Shriki in that regard.
Yes.
I have asked the clerk of the Senate to pass around some material that I thought would be of assistance to all of the members who are considering how to vote in this particular matter. And one of the pieces of legislation that I've passed around is the Tax Appeal Board Act. And it is not right, Madam President, for us to simply make reference to the Tax Appeal Board and say that is the way it operates in the Tax Appeal Board. The Tax Appeal Board is composed differently from how this tribunal is composed. The conditions of employment and the security of tenure are different under the Tax Appeal Board than how it is here. Under the Tax Appeal Board Act, when one reads the Act, you will see that the chairman and the vice chairman are appointed by the JLSC. The chairman is to enjoy the same salaries and allowances as a judge of the High Court. His salary is charged to the consolidated fund. All of these security, the independence is not about simply saying they're appointed one person. This is a very serious matter. And saying that you can take one member, I don't want to use a colloquial example, but you can't have halfway independence. It is either you are independent and insulated or you are not. So at the end of the day, when one looks at the provisions, everybody has it on soft copy. When one looks at the provisions of what applies to members of the Tax Appeal Board, it is different. And the fact that it has worked in one, the point that Senator Choate makes is a point that has been canvassed in the Court of Appeal and in the Privy Council by the fact of saying the fact that it has worked in one particular tribunal is not a good reason to come here and say, well, it will work here as well. We are here with the opportunity to get it right. And that is what we are trying to do. So that the examples, we can also say that is the way it operates in the industrial court.
Okay, but Senator Ramdeen, I think...
No, but there's one point I want to make that is very important.
Okay.
When the Attorney General was piloting this particular, explaining this particular provision and how it operates and why it is independent, the Attorney General cited a number of cases. And I have put all those cases for everyone to have a look at it and read it. But the difference between the industrial court, which is appointed by the cabinet, the Court of Appeal has said the reason why that is not in breach of the separation of powers is because the experience has shown that they have exercised their jurisdiction in a particular way. You cannot have that same test in a tribunal that is being created for the first time.
Okay. Senator Haynes? I just wanted to make the point that when the minister was speaking, the minister said that the Tax Appeal Board operates somewhat independent, and that's exactly what we're trying to cure here is the illusion, or that okay, I'm sorry if I misquoted you, but that's the impression that I got. And it is that what we're saying is, because this is so important and you're dealing with people's property, etc., that you have to be very careful looking at the independence of the tribunal. And so that's what we're proposing, that when we do this, it is truly independent and not just an appearance of independence. Senator Hussain?
Thank you very much, Madam Chair. I just want to join us with Senator Ramdeen with respect to this matter, because you're establishing a judicial body, and then two members, the majority of members, are being appointed by cabinet. Now, when one looks at the Interpretation Act, it now means that cabinet has the right to suspend, discipline, and even set the remuneration of these persons, because the one who has the power to appoint also has the power to revoke, and the other powers are even listed in the Interpretation Act. And I'm saying that, how can we say that these persons will now be operating without the pressure of the minister or the cabinet or even the entire executive Because truly, you have a chairman operating with two political appointees. So that can never be an independent body. So there's no protection offered for these other members or even the chairman of this entire valuation tribunal.
Senator Mahabir.
Thank you very much, Madam Chair. It builds upon the concern expressed by Senator Hussain prior, and that is majority rules. 2 out of the 3 are members appointed by the executive. I think it is going to be potentially very unworkable with 2 members who can vote against a chairman on a continuous basis. And this is new law, as Senator Choate indicated, and I think I am not really getting from the government what is the problem for having all 3 members immune from political influence.
Senator Roach, you had indicated, no? Okay. Senator Shriki.
Thank you, Madam Chair. I just want to raise one point with reference to the Tax Appeal Board, and somebody could correct me if I'm wrong, but the Tax Appeal Board is not a division of the Ministry of Finance. So if it's not, then, so that's why. So, that's the point. Where you have members being appointed by the Minister of Finance, or by the Ministry of Finance, or by the Minister of Finance for a tribunal that is resident there, that's held in the same ministry, and that's the point.
Senator Mark, you no? Yes, but we go in. Yes, Senator Amin.
Yeah, thank you, Madam Chairman. Madam Chairman, I just want to say that I know and I understand that the Minister is coming from a practical perspective, having experience in that ministry and with some of these departments firsthand, and how the board operates. But I think in the debate, many of us made the point about insulating the board from the from political influence, and I think we are making the same points again. The Tax Appeal Board that you referred to, although you are referring to how they operate practically, the fact is that they have different terms and conditions. They have different, that I think offers them additional protection that the present valuation tribunal does not have. So, which is why I am endorsing the point that was made and further strengthen the argument and asking you to give consideration to that, but also appreciating that I know you are offering from a practical sort of perspective as to how it works. But that protection that exists sort of behind the scenes would be absent in this case. So I'm pleading with you to give consideration to the amendments proposed.
Minister.
Madam President, I would thank the members on the other side and the opposition bench for their comments. The government has reconsidered the position, but we are of the view that the compromise position that we offered earlier is sufficiently adequate to provide the protection, having regard to the fact, I will say again, that this is not a court of first instance, that the owners of property who have challenges have 3 courts over and above the tribunal who are there to protect their rights if they think their rights are violated. So in those circumstances, Madam Chairman, we think that the formula that we have provided is adequate.
Okay. So So, Minister, you will be amending. You had proposed an amendment, and therefore, is it that you're going to further amend that amendment? Do you have the wording, or will you need some time?
If you give me a couple of minutes, Madam President.
Yes.
And,
no problem. Senator Mark, let us... members, I'm just going through all the amendments, and then we will take them one by one. I think Senator Mahabir has withdrawn his. So, Senator Mark?
Yes. Madam Chair, the mere fact that we are having so much difficulty in a simple tribunal tells me that there's great justification for us retaining by pumping more resources into the Tax Appeal Board of the Republic of Trinidad and Tobago. I cannot understand, Madam President, Madam Chair, and maybe the Minister can tell us what is the rationale for the government's hesitance for promoting an independent tribunal. Madam President, may I say that justice must not only be done, but must be seen to be done. And I listened very carefully to the Honorable Minister's contribution earlier on, where the Minister spoke about this tribunal exercising judicial functions. How can a tribunal exercise judicial functions if it is under the control of the politicians and the cabinet? It just does not make sense. And, Madam President, hence the reason we objected to the tribunal. And we said we already have a structure in place called the Tax Appeals Board. Let us go with the Tax Appeals Board and let that board, as I said, be properly resourced. Now, Madam President, Madam Chair, this body is going to have a lot of information. And one wonders why the government is seeking not to have an independent body. Why is the government seeking, or why is the government, Madam Chair, so afraid of having 3 independent members of this tribunal adjudicating over sensitive land matters? Why is the government afraid? I haven't had any justification from the government side as to why they are afraid of having a truly independent tribunal. And, Madam Chair, I can only assume, and that is why I want to say to you, I had asked the Honourable Minister earlier on, what protection is there for this sensitive information coming from 700,000 property owners? And we didn't get a proper answer until Senator Ramdeen told us that large section of the Data Protection Act is still not proclaimed. So it means to say, Madam Chair, that all this information is being given to a group of people that we have no assurance the information is going to be misused. And what have me more suspicious is the government's decision here this evening not to adhere and not to support the establishment of an independent tribunal. It consolidates, in my mind, that there is something more in the mortar than the pestle. Because, Madam President, why?
Tamar, please, let us not go with those kinds of imputations. Please, you can make your case as you are doing it. But don't say, refine what you're saying, please. Please.
All right, I'll be guided by you. But you know, I can't help what I've just said. Madam Chair, so here it is. We have advanced that the Tax Appeal Board is properly constituted in law. As I said, it is a superior court of record. Members' salary, like the chairman and the vice chairman, directly from the consolidated fund. These people cannot be removed. They have security of tenure. And therefore, all the evidence is before us why we should go with this body called the Tax Appeal Board. And therefore, we reject completely this valuation tribunal, it is not going to serve the purpose that the government believes it will serve. And Madam Chair, if the government wishes to do what it wants to do, there are certain constitutional infirmities that I constitutional infirmities. Okay, infirmities that we are seeing in this legislation. And if I were the government, and the government understand the separation of powers, they would be very, very mindful that this matter, if it is not handled properly, Madam Chair, you're an attorney at law, you know how these things go. So this is to tell the government, do not go down a path that is going to be deemed otherwise somewhere else. So I want to advise the government to rethink its position. I believe, Madam Chair, that the Honourable Minister means well. I believe that the Minister would like to have the President appoint the tribunal on consultation with the Prime Minister and the Leader of the Opposition. But as the Honourable Minister has indicated, they have instructions and they are operating under government's policy. So if that is the government's policy, we cannot change the Minister's mind. So I would pause at this time, and we'll have to take the vote and let the chips fall where they may. I will close my case at this time.
Senator Rafool. Thank you. I also support the amendment that all members of the tribunal be appointed by the President in her discretion. I think that our role here is to prevent loopholes and to prevent potentials for abuse of power or political interference in our legislation. And to say that, you know, citizens can always appeal, which is extremely expensive to do so, or to go to the courts, I think that is a weak argument. I think we have to make sure that we try and protect citizens as much as power and have things that are based on merit and transparency.
Senator Ramdeen.
Thank you. I see that the amendment that Senator Mark, I'll be guided by you, Madam Chair. I see the amendment that Senator Mark has said is to delete the entire subsection. So am I able to speak to any one of the subsections under 25 in that amendment?
Senator Mark did.
Well, no.
So you can.
Okay. Oh, okay. Thanks, Madam Chair. I know a little bit about public law, and there is a section here that much was made of about the minister shall not give directions to the valuation tribunal in respect of any particular application or proceeding before the valuation tribunal, or a direction that would derogate from the duty of the valuation tribunal to act judicially. Public law and legislation that prescribes public powers is based upon two things. A public power is supposed to be exercised in an environment of legality. It's called the principle of legality. It is supposed to be exercised reasonably, and it's supposed to be undermined by a presumption of regularity. How a statute can enact that a minister must not do something unlawful is incredible, because I have never seen in the little bit of legislation that I've read, I've never seen a statute prescribe that a minister must not do something unlawful. Because the entire presumption of the exercise of public power is that you must do it lawfully. So the fact that we are doing the reverse, which is prescribing that you should not do it unlawfully, means that there is a presumption that you're doing it unlawfully. And I have never seen a provision that says a minister shall not give directions. There's a provision here that says the tribunal shall conduct its proceedings without procedural formality, but shall observe the rules of natural justice. Where does a statute prescribe that a tribunal that is exercising quasi-judicial functions must observe the rules of natural justice? That's a presumption. It's expected that you will observe the rules of natural justice. So this is another provision that presumes, for some reason, that the tribunal will be acting in breach of the rules of natural justice, so we must prescribe that they must act lawfully in exercising judicial functions. So what I want to suggest, Madam President, in accordance with the policy of the government is this, and I am serious. We have a Judicial Review Act in this country, and it prescribes all of the grounds for judicial review. It's statutory, so I think we should amend the law, and we should prescribe in accordance with Section 5(3) all of the grounds that one can apply for judicial review. We should insert all of the grounds and say that the tribunal should not do any of these things, because these are all of the bases upon which you can challenge a public power. So why limit it to natural justice? And why say the minister should act lawfully? Let's go to all of them. They shouldn't exercise excessive jurisdiction.
I think your point has been made. Do you have a further point?
No. I just think that I want to just say, Madam President, that the cases that are cited here by the Attorney General, I did all of them. I don't apologize for doing them, and I have won all. So I can say with a certain degree of experience that what we are doing here is a very dangerous thing. And based on the authorities, it is clearly unconstitutional. And I'm saying that having represented the state in all of these matters.
Senator Hussain.
Thank you very much, Madam Chair. Now, there's one comment that the minister made that had me very concerned, that I got the impression that once there's an appeal, it means that the entire process is independent. And I want to disagree with that, because there's a right to appeal, how does that make the tribunal independent? It no way does that, because at the end of the day, you still have persons who are appointed by the executive sitting and making these decisions of this tribunal. And I also want to put on record that I support the point that Senator Raful made with respect to the expense of appeals. These are poor persons we are going to be dealing with, Madam President. How can they afford to access higher courts? And my last point on this is why it is that there's such a fight down for us to ensure independence of a judicial body. That concerns me a lot, because we should not be here arguing at 8:34 p.m. in the night that we should have persons exercising judicial functions not be appointed by the executive. I think that goes without saying.
The thing about all of this that has me concerned is the term of office. I think we had agreed on 5 years or 3 years? 3 years. So which gets us into the first year of whatever administration precedes the current one. So I think that is the point about which we should all be concerned, that whatever we institute now would redound to the advantage, whatever way we perceive it, of the current administration. But the same would apply to the successive administration.
Madam Chair, there are two issues before us in respect of clauses 25. One in respect of the composition, the appointment of the tribunal, and the other in respect of the term of office and temporary inability to act. With respect to the latter, Madam Chair, we are prepared to accept the suggestions of Senator Ramkisoon with certain amendments. And I'm happy to propose those now. At A of the proposed amendment, which seeks to insert a new clause 5, we are proposing to replace the words at the beginning, notwithstanding that a member's, I'm assuming, term of office has expired, with the words where the term of office of a member has expired, comma, he may, comma.
Just a sec.
Sorry. we are deleting, notwithstanding that a member's term of office has expired, and replacing it with, where the term of office of a member has expired, comma,
where the or where a? Where the term or where a
where
term?
the term.
The term. Yes?
Has expired, comma, he may, comma. And then it continues with the permission of the president and so on.
Out of clarity, my version has the word, the advice of the minister. Is minister remaining there?
That is
chairperson.
Chairperson. Thank you.
Okay, so that the further amendment to the proposed amendment will read as follows. Where the term of office of a member has expired, comma, he may, with the permission of the president, acting on the advice of the chairperson, continue in office. That's
Yes,
it, right?
yes,
And the rest, okay.
With respect to amendment at paragraph B, Madam Chair, we propose to amend the reference to section 25E, so it's D, right, to section 25D.
So in the proposed section 25D.
Yes, and we accept the proposed amendment as suggested by Senator Ramkisoon.
So, right, so will it be insert after the word 25E or D?
D.
At 1. So you have B in the proposed 25D dash
Yes.
1, insert after the word. Would that be 25D or 25? That stays?
Yes. No, it will be D. This is also D. D, yes, that's what I said. Yes.
So it will be insert after the word 25D.
D.
The word 1. And then, and 2, insert the following new subsection.
That is correct,
Okay.
Madam Chair.
Minister, before I put the various proposed amendments to the vote, I believe you still have some housekeeping to do.
With respect to the other the final proposed amendment,
Yes.
Madam Chair.
Yes.
Madam Chair, I would like to crave your indulgence for us to suspend for 15 minutes so that we can come to a final determination on what position we will adopt.
So, honourable senators, this committee is suspended until 9 p.m. We will return at 9 p.m.